Mr. Chauvin, as to count one, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense? All right. Thank you. We are adjourned.
And that is the moment we have been waiting for. Derek Chauvin sentenced by Judge Cahill to 22 and a half years behind bars. So the prosecution was asking for 30. The defense was asking for probation, getting 22 and a half years. Joey, your thoughts on that sentence? And the bigger point here is, how much will he have to serve?
Yeah, I think that's an important point to make. But to the first issue, look, what the judge did here is say we have sentencing guidelines, and based on those sentencing guidelines, it would have been 12 and a half. What I'm looking to do is enhance it by 10 years, right, to make it 22 and a half years. I thought he would go and acknowledge and give the 30 years, and we don't know as to why he did not do that. Of course, he mentioned the 22-page memorandum that he has, and I'll be looking through that memorandum to otherwise give the indication of why he did what he did. The judge being very matter of fact, saying, look, I'm not doing this based on public opinion. I'm a judge. I follow the facts. I follow the law. I apply to specific cases, and this is why I do what I do. But I do believe, though, Susan, again, and I say this trying to be as objective as I possibly can, based upon what occurred here, what we all saw here, and based upon the finding of four aggravating factors, I thought the judge would go higher. Last point, why? Because remember what the prosecutor said. If you have a finding of one aggravated factor, the precedent establishes that you can double the guideline, which would bring you to 25. If you have here 4, then you would think that that's, would give you a good basis to go even higher than that. But look, that's what makes a judge a judge. I'll review and evaluate what his findings are legally, but I just think at first blush, sitting here, evaluating, looking, doing from the outset, I thought that 22 and a half years was significantly less than, I anticipated.
And Misty, the judge adding also, I don't base this decision on emotion or sympathy, but pointing out that he does understand the pain for both families, and he did say especially the Floyd family, that he feels their pain, he understands. Misty, your thoughts on the 22 and a half years?
Well, look, I think one point to be made, we're talking about a 22-page memorandum. I think as what Joey was talking about earlier, seems like Judge Cahill really had in his mind what he was going to do before walking into that courtroom today. And Susan, to the point you just made, he specifically said that he's basing his decision on the legal standards as opposed to that the sympathy and the public opinion and all of that. So I thought that was very interesting to hear that 22-page memorandum appears to already have been created, right? So look, I agree with Joey, not being so adverse or in-depth and familiar with Minnesota law. I'm very interested to read the memorandum and see what precedent this decision was based off of. I did think with 4 aggravating factors, we might see something a bit closer to that 30. And it seems like in his decision, although Judge Cahill said, I'm not going to really get into it here, you're going to read the brief, he really only talked about 2 of the 4 that were found. So I'm interested to see what that case law is. And like Joey, I'll be really parsing through that to see how this came to be.
And Ariva, I know you were speaking before we went back into the courtroom to hear what the sentence would be. Your thoughts on the 22.5 years, and I'm wondering, in the state, how much of that time will he actually serve?
Well, I'm disappointed, Susan, in the 22.5 years. I think the argument that the prosecution made was dead spot, just dead on. I think it was appropriate to ask that the sentencing guideline months be doubled, given the 4 aggravating circumstances. And I think despite some of the issues I had with some things that Matthew Frank said, I did think that he laid out very carefully and thoroughly the aggravating factors that would have justified doubling from a 15-year at the top of the pre-sentencing guideline sentence to doubling that to 30 years. What we know about Minnesota law is that Chauvin is likely to only serve 2/3 of that time. Under Minnesota law, someone sentenced to X number of years, like in this case, 22.5, they don't have to serve out that entire time. But there is still these federal charges that are pending. So it's not, guaranteed at all that he is only facing time with respect to the state charges. There's a great possibility that he will be tried or perhaps enter into some kind of plea deal with the Department of Justice that could add more time onto the sentence. And just real quickly, Susan, what I was saying before we went back into the courtroom is that I took real issue with Frank thanking police officers for telling the truth and for breaking the blue wall of silence, because we've been talking about how do we get to real change with respect to policing. And it's not about who you hire, because if you bring people into an environment that is cancerous by nature, that is corrupt by nature, those people will just become a part of that corrupt culture. And that's the culture that we have to change. We shouldn't thank police for doing their jobs. We should expect them to do their jobs and expect nothing less of them and hold them accountable when they don't. So any officer that did not come forward, that didn't do what was right with respect to George Floyd, should be held accountable. And those officers that have been commended in the past for breaking that blue wall of silence, they need to get the message that it's a new day. And it's not about protecting police officers, it's about protecting civilians.
Ariva, excellent point. Darren, I want to get your take on this. Was it that he was thanking police for doing what Ariva attested to, or was it a nudge to say this blue wall of silence exists for those who don't know about it, and the end of it needs to come immediately, and mentioning it in that way? I know it's a convoluted question, Darren, but your thoughts on what he was speaking to, the prosecutor?
My assessment to the prosecutor's statement was he was wholeheartedly thanking the people that were part of or contributing factors to availing him to a guilty verdict in this case. I believe that's the lens that he focused on. Now, I understand to Ariva's point that officers are tasked to do what's right no matter what the circumstance. I have that. But I look at it from the perspective, from a universal perspective, so to speak, is this was just a Herculean case. There were so many moving parts in this, and the prosecutor was merely introducing a thank you to the officers for contributing to the guilty verdict as a result. But just one other thing that I just kind of want to make mention to, does this change the trajectory for policing moving forward? I don't necessarily think that it does. I think you have a lot of systemic practices within policing that need to be changed. And I think a lot more technological innovations are being injected into policing, like as we saw here with video that was able to reflect on what an officer did. We have more and more officers that are wearing body cameras in the country, and I think that that's going to be a contributing factor. So when you look at it from a comprehensive perspective, we have different components that are coming into play, and this is just one of those components. But I don't see this as a sole factor that's going to change policing. There are other issues that are coming into play, and I think the evolution is happening, but it's moving at a more glacial perspective as opposed to the rapid succession that we're looking for.
That has been a never-ending question since this began, meaning First of all, why was his knee on George Floyd's neck with handcuffs on? He was obviously not moving, not going anywhere. So why didn't he take his knee off of George Floyd's neck, especially with the cameras, meaning cell phone footage, Joey? So will this change maybe the way a police officer sees his job, meaning I don't want 22 and a half years behind bars?
You know, Susan, I really believe it will. I think that there are moments in time and moments in history that are reckonings. You think about, just to draw the analogy, not to equate, but to draw this analogy, that's what we lawyers do. You look at Me Too, you look at Time's Up. There's a point in time where people come together and say, we're mad as heck. We're not going to take it anymore. I've been violated for too long by people in positions of authority, and it's over. It stops today, it stops now. And so if you equate that to this, where you have just in the country an over-policing of communities of color, police who have really just abused their authority in neighborhoods and just have gone in, showed no empathy, no sympathy, no anything, have escalated matters. And I have to believe, again, though the process is slow, and my friend Darren Porcher likes to use the term, and I agree, a glacial pace, right? We know how slow they move, and that's true. And we all hope they move quicker. But I have to believe, Susan, that this sends a compelling message, a message of reckoning, a message of accountability, a message of the time is now. And so you, officer, over there, when you're thinking about doing something that would degrade a person who is a father, who's an uncle, who is a son, whomever you are, think twice about it, because you too will be held accountable, and you too will be in jail, and you too will be treated like everyone else, no matter that you're wearing a uniform and have a badge and a gun. And so, yes, I do believe, I'm cautiously optimistic that this changes things. It's a game changer in my view.
And saying his name, it was spoken outside of the White House a year to the day that George Floyd died, and his daughter Gianna starting that chant saying her father's name. He meant something. It means something to do this. Want to go outside of the courthouse to listen in on the reaction.
Let's talk about shit behind closed doors. Let's talk about how they keep on killing us black men. Let's talk about Let's talk about black men